Hello, this is Mark Smershel. I'm Vice President and co-presenter for BeneFLEX HR Resources. Today, this is an introduction to 3 separate educational webinars, and whether you're joining us because you're interested in Part 1, Understanding the FMLA Employer Requirements, Part 2, How to Identify and Investigate FMLA Abuse, are 3 focusing on ERISA and Department of Labor audits, you're going to be excited because all 3 of these webinars were approved by SHRM and HRCI and the Department of Insurance for professional credit at the seminar we presented a while back. So when we're talking about BeneFLEX, we want to make sure you understand we're a third-party administrator that focuses on pre-tax accounts. We were started 23 years ago by Jim Smershel of Smershel and Tallor, and we work on these accounts with many clients in the Midwest and on both coasts. Most recently, we added services due to ACA. We added the reporting. And in January of 2017, the Qualified Small Employer HRA was brought forward as a way for small employers who don't offer insurance to reimburse their employees' individual health care coverage costs through an HRA. Now, when we're talking about BeneFLEX, we wouldn't do anything without our partners that we work with. And these are some of our clients that are very strong partners when it comes to benefits, and they drive a lot of the services that we bring forward because they share their needs with us. And it's the BeneFLEX team that is here to help you when you call in, and all team members, when you reach BeneFLEX, will help you with your plans, or they can help get you to the person that knows about their plans, because each one is certified by the Employers Council on Flexible Compensation. But the other part of BeneFLEX that you don't see is the partners behind the scene. Our Bene card, or the red Bene, has been around for 20 years and has been meeting the needs of flex programs for all of our clients. Well, that partnership is very dependent upon a second partnership, which is the financial institutions behind the scene. The HIPAA high tech and the protection that we bring forward from our IT partnership, and the customer service and IVR that we have available. The programs that run the software, the Flex, the HRA, TMA, all of those are a partnership with WEX Healthcare, and that works with Allegis, which makes the card work at the pharmacies. And then lastly, we have Smershel Tallor, our sister company, who is a very strong partnership with the audits and controls they have in place to make sure that your accounts and your plans are kept in compliance. So why are we here today? Our partners, meaning our clients, were very good about bringing back the surveys that we sent out, asking what were some areas they needed help in. And 74% of you very strongly identified FMLA as something that you wanted additional discussion or you wanted additional help with in terms of the resources. So to do that, we had to go out and find a new partner. And BASIC is that new partner, because BASIC is a top 25 HR technology winner in 2017. So what that means is by finding a strong partner on the technology side, BeneFLEX can take that technology and be a conduit for all of our existing clients and new clients that need FMLA or ERISA, because by having a large amount of volume going through, we can get you a package price and a better deal. And you already have a strong relationship with BeneFLEX, so why start a new one when you can work with a trusted partner? So in speaking of trusted partners, I want to introduce Joe Aitchison, who is going to present the two presentations on FMLA and the one presentation on ERISA. Joe is a human resource professionalist with over 25 years in the business. He is recognized as a leader in that profession, and he has obtained a lifetime certification as a senior professional in human resource management by SHRM. He is a certified senior professional and HR specialist by Healthcare Reform Centers and Policy Institute. Here's Joe.
And we'll start by saying that our partners at BeneFLEX, you can't be in any better hands. I love these guys, not only who they are as individuals, but what they represent. The character of any organization speaks through its ownership, and here, these guys are wonderful. The whole team is wonderful. So thank you very much for having me out. I'm 25, and look at me now. And that's because of compliance stuff. And this is what you're going to look like in another 5 years. So we'll start with that. And I also want to say that I'm not going to speak to you like a CPA, God bless you guys, and an attorney. I'm going to speak to you like one of you. I don't really care, I'll keep my colorful language to myself, about the regulatory issues themselves. I care about them, but what I care about is the practical aspect of what you deal with on a day-to-day basis. That's what I do working with our folks at BeneFLEX and the folks at BASIC and our over 15 combined 25, 30,000 clients across the country. And I'm going to try to share that with you today on FMLA and ERISA. The other part that I have to explain before we get started is that I'm Italian. My mom was from Italy. I speak a lot with my hands. I go like this a lot and stuff. And so if you happen to be sleeping or nodding off and this thing flies, it's not really because of that. I apologize. It's just that I get too excited. And I do get excited about this stuff. And so what we're going to talk about today is the Family Medical Leave Act, FMLA, to start. We're going to cover a lot of stuff, and we're going to gear this first part of the presentation on what it is. And for those of you that are going to stay for the second session that happens after lunch, hopefully you can, we're going to talk about some problematic issues that if you haven't encountered, you will. Now, personally, I've worked with a lot of different clients with the friends that we have over at the Department of Labor on FMLA complaints. And so I'll be salting our presentation with regard to the reality of life from your perspective and the oh crap moments that you have to deal with, and God bless you, okay? So we'll start there. We're going to talk about what typically are your employer mistakes, a little bit of best practices, COBRA, and our friends at the DOL, and then we'll go into a Q&A. Sound like a plan? Okay, let's get going. When they created this thing a few years back, this is directly from the Department of Labor. FMLA is controlled by the Department of Labor. And for all intent and practices, you guys follow the Fed FMLA. You're not like California or some other states, or Oregon. You don't have to worry about that much state leave stuff. But saying that, look at what's highlighted here. Workers should not have to choose between the job they need and the family members they love and who they need to care for. That's the position of the Department of Labor. Does it say employers are all great and wonderful and whatever you do is right? It does not. So if you look at the basic philosophy of the foundation of FMLA, that pretty much tells you workers aren't just contributing to the success of the business, but away from their jobs, they are contributing to the health and well-being of their families. And we all agree for that. Old folks like myself, we live to work. That's what we do. And some young folks, they don't necessarily live to work, they work to live, right? And that's frustrating for a lot of you, and I get that. But that's the culture and philosophy that we in business have to work with. These aren't Joe's words. This is the Department of Labor quote. Interesting. FMLA started a few years back, but really, just to go through the basics, 12 weeks of leave, bonding, serious health condition, you guys know that stuff, right? Don't have to go into too much detail about that, but generally speaking, we'll get into it in a little bit more. FMLA eligibilities is for 12 weeks of job-protected leave, got that, or 26 weeks if you're a military, okay, up to 26 weeks of time to care for an injured service member. When you take a look at eligibility for FMLA, did you know that, kind of like a 401k, that there's a look-back period for your employees? So when you rehire somebody that worked with you 3 years ago, they don't have to, it's not, did they work with you for 1,250 hours, or have they been here 12 months? They started this year, I'll just say, January 1. They haven't been with you 12 months yet, right? Well, they don't qualify for FMLA. The answer is they worked for you 3 years ago, and you have to give them credit for that 12 months of time, even if they worked with you up to 7 years ago, okay? Kind of like a 401k, you give credit for past work history, same kind of thing. And that takes care of the 12 months, but then they must have also worked 1,250 hours in the most recent 12-month period. Make sense? Okay. They must have a reason to take FMLA, and leave can be taken in weeks, days, hours, or minutes. That's the problem. Weeks, days, hours, or minutes. We'll talk a little bit about that as well. In your policies, you should identify what 12-month leave period that you're using. You can have a look-back period, a look-forward period, base it on your fiscal year, base it on a calendar year. My recommendation to most of the employers that we have, and we're processing approximately 2,300 new certifications per month and over 3,500 events per month total. So when we work with our clients across the country, what we're doing is we're saying use a 12-month look-back period is the best way for you to track your FMLA. And we'll talk in detail about that as we go through today's presentation. It covers the employee, children, under the age of 18, and adult children over the age of 18, parents, a term in loco parentis that we'll identify, okay, and spouses, next of kin, military service members. When we look at children under the age of 18, all that stuff up there is applicable: biological, adopted, step, foster, legal ward, or custody. One scenario I'll give you as an explanation when we take a look at legal ward and custody. Under custody, it doesn't have to necessarily be legal, okay? Show me the adoption paper. Show me that you had a right to take care of this under age 18 child. So in other words, I'll use a student exchange, an exchange student from Europe comes to live at your house. They've been there 6 weeks, and then all of a sudden you know that you discover that this exchange student has a chronic allergy or asthma or whatever and needs to have health treatments, and sometimes if they have an allergic reaction, they can't do what? Take care of themselves. Is that FMLA? They're not your child. The answer is yes, it is, because you have legal custody. In loco parentis, I'll cover some of the slides and I'll skip over them a little bit later, but in loco parentis, in place of a parent, is what? That child that was raised by a grandparent. by an uncle or an aunt. Now, how do you prove that? What kind of legal documentation can you ask an employee for? What is the Department of Labor under their philosophy going to accept, right? Pretty simple. Give me a note or a statement in writing that says your grandparents raised you is sufficient for the Department of Labor to accept that. You should get it in writing. Because you know why you want it in writing? It's because, I was raised by my grandparents on all sides. I can take FMLA for all 12 grandparents that I had. Okay? But what happens is that maybe that's not so true, right? But you have ethic policies in place too. And so if an employee is less than truthful with you, they're trying to get something over on you. Can you do something to them? Absolutely yes, because they falsified information that the company used to make a business decision. So you can take disciplinary action, and you know the drill, up to including what? Yes, exactly. And that no matter if they jump up and down, call the Department of Labor, or do anything, they're pretty much done. When we look at in loco parentis, as we talked about the parent stuff, be very, very careful, and please make sure you do get that in writing. I'm just going to leave it that way. And that will stand up with the Department of Labor. No question about it. Failure to have that in writing, then you know what happens? It's a misunderstanding. Well, I didn't really say that to my employer. They just kind of interpreted it that way. And they fired me for it. Oh, well, that's not the case. But now you have to defend your actions. But a simple statement asserting that relationship is sufficient. Adult children. I'm going to go to the ADA, Americans with Disability Act, as amended, ADA, AA, or ADA. And there's things that are called IADLs and ADLs. Activities of daily life are the ones over on the right-hand side. That's bathing and showering, being able to go to the bathroom, dressing yourself, that sort of stuff. And then IADLs is instrumental activities of daily life. That's like doing housework, being able to maintain the house, taking medication, doing that sort of stuff. So that's what the ADA looks for. When you look at it from the perspective of FMLA for an adult child, this may be an adult child that has some mental challenges that needs care, right? So those kinds of things, if it meets that criteria under the ADA, that's what the FMLA is going to look at, so that when an individual employee needs to take some time off for that type of situation for an adult child, does it mean that a grandmother or a mother can go take care of her daughter and her newborn under FMLA? The answer is it doesn't work that way. They'd like to, and God bless them for wanting to do that. And the mom, their daughter would probably love to have that happen as a help, support. That's a different thing than trying to get the FMLA for it, okay? Doesn't work. The psychological stuff. I work for you. I give you a call and say, my wife is having, she'd kill me if she heard me talk about her like this, she really would. It's not true, but she's having one of her bouts again, depression or anxiety. And I have to stay home with her. So I call and tell my boss, and it's FMLA, right? However, what happens is that one of the third shift folks stops and grabs breakfast at the local restaurant, and I'm there with my wife yucking it up. Later on in the day, because I'm off on FMLA, intermittent leave, Friday, payday. I'm seen at the local mall shopping with my wife by another employee. They come and tell you, Joe's not taking FMLA. I don't know what the hell he's up to, but he certainly is off plan, right? Okay, you've had it. You've heard it from at least 2 employees. Am I on FMLA or not? Rhetorical, don't answer that. Just think about the question. Am I on FMLA or not? The answer is yes, I am. You know why? Remember that philosophy the DOL has? And here's the definition that it will go to. The mere presence of the spouse or that family member is sufficient enough if it's a diagnosed type of condition of anxiety, depression, psychological. The mere presence. Now, from an employer's perspective, you're thinking, that kind of sucks, right? But the answer is, think of it from the family perspective. What happens if I'm not there with my spouse and she harms herself? You see where I'm going? Little different. Do you work to live or you live to work? Look at that philosophy and look at it from how we think on a day-to-day basis versus how we think as an individual. It's a different perspective. So make sure that you go through that certification process. Traditional marriages, same-sex marriages, all of that sort of stuff. And the good news is that Missouri does not recognize common law marriage since 1921. So I researched that. We're cool there. Common law doesn't work. So same-sex marriage, licensed marriages do work. Here's what you need to be thinking about. Been there and done this countless number of times. Remember, I'm 25, working with the DOL. Now, the Department of Labor, God bless them from the standpoint, and EEOC, they have a mantra or a flow that they always follow. Every audit or investigation I've ever worked with an employer, it follows the same process. There's a process flow. Already know it, know the drill. It follows exactly down a certain list. And here's the stuff that they kind of asked for, right up here. Did you do your posting? They can talk to whomever they want, the Department of Labor, whenever they want. If they didn't get enough, they can come back and visit. They can call your employees. They can do whatever they want to do. You don't own the employees. The Department of Labor owns those employees. Whether they choose to talk to them is their decision and not yours. Okay? And so looking at the posting, what we're looking at is notice of eligibility, rights and responsibilities. Please make a note of that. If you can get that right from the Department of Labor, but make a note of that because this is a failure of employers not to give that notice of rights and responsibility. Now in the second session of FMLA, we're going to talk about what that should include on there. Okay? I'm going to use a term now kind of to tickle you for a little bit later stuff and write down extenuating circumstances. Okay, that term. And if you want the CFR to look at, 825.313 parts A, B, and C. It's a wonderful one that doesn't do you very much good as an employer. But we'll talk about that a little bit later. So 380E and the 380F are the designation notices that the FML or the Department of Labor uses. E is for employee, F is for family. Please use these forms. When you Google these forms and you print them off, don't add your logo to it. Don't make any changes is my recommendation. I get calls from employers. Hi Joe, how you doing? No one ever calls to say, hi, how are you? They just don't anymore. I listen. You did what? Why did you do that? And then that's that whole crap. Well, yeah, we used the Department of Labor forms, but what we did is we didn't really like it. We kind of tweaked it a little bit. We added a couple words to it, and then we added our logo to it too. Why did you do that? Because the minute that you tamper with that form, then is it the government form anymore? No, it's your form. And a friendly attorney and a Department of Labor person can pick it all apart. Now, typically, if it kind of looks like the Department of Labor form and you didn't do too much to it, an auditor, most of them, unless they're newer or what we'll call a stickler auditor, are going to let that go. Okay? So you've got those forms. You've got the other things that you have to do on your timing here would be the 15 calendar day. Are you familiar with the 7-day cure rule? The 7-day cure rule is that when that healthcare provider for the employee is taking a week off to go golfing or something like that, and they say they can't get the form back to you in 15 days, they have 7 days cure additional to get that form back. So typically what I tell employers, is that what they should be looking at doing is allowing the 15 calendar days plus an additional time, maybe 2, 3, 4 if you're transacting stuff through the mail. So up to 22 days. 7 and 5 is 12, 15 plus 7, 22, is to pick up that 7-day cure. Okay. And then we'll also talk about how that extenuating circumstance stuff goes to the next. FMLA is for incapacity and treatment, injury, illness, impairment, or physical or medical condition, inability to work, attend school, or perform other regular daily activities, that IADL and ADL stuff that we talked about a little earlier. And also treatment is prescription drugs, physical therapy, occupational therapy, psychological stuff, which my wife talks to me about every now and then, that I need, stuff like that. I call it the 3-2-1 rule, just to keep it simple. FMLA requires 3 consecutive full calendar days off. Did I say work days? No. If you have a flu condition that was Saturday, Sunday, Monday, is that 3 calendar days? So it's 72 hours plus a minute, okay? How do you supposed to know about the Saturday, Sunday flu thing? I don't know. Have you ever heard about that animal that's called a halifino? I mean, picture that in your own brain. What does that animal look like? And I bet you some have feathers, some are green, some have scales, looks more like a fish, others look like a dog. It's a different picture. And when an investigator from the Department of Labor comes in, it's kind of like that halifino, because every FMLA claim, even though they go through the same process, is uniquely looked at for its own specific stuff. Not anything that's going to be bundled. We'll get to what they bundle a little bit later. So on a chronic condition, 3 consecutive calendar days, 2 visits to a healthcare provider, that's the 3-2. 1 visit is within the first 7 days, and the second visit is within 30 days. I'll give you an example. Joe has the flu Saturday and Sunday and Monday. He calls in. Let's say he's off, because you don't really care about a 1-day absence anyway, typically. Please, God, just come to work. That's all you care about. Please. Or some of them you say, please, God, don't come for at least 5 days. Please. Then I can get away with it. There's no attorneys here, right? No, I'm kidding. And so off for 3 days, I go to my doctor, and my doctor goes, yep, you got the flu. Okay, great. Go take some, I don't know, flu tablet stuff. Stay off of work for another couple days and go back to work. You're good to go. So now I took my doctor's advice. I'll write you off for 5 days. You want more? I'll give you 10. What do you want? I'll just put it here for you. And you guys know exactly what I mean, right? And oh, FMLA. No. Did he go to the doctor? Did I go to the doctor twice? I went once, and I'm taking some sort of over-the-counter. Doesn't qualify. Now, if I have the flu, I go to the doctor, and the doctor goes, yep, you got the flu. Here's a prescription I want you to take. And also come back in a couple weeks. The answer is, I got an FMLA. And it's covered. Yes?
Does Teledoc fall into that?
I'm sorry?
Does Teledoc fall into that?
Oh, you are good. That's under ERISA. I'm sorry, I don't cover it under FMLA. No, I'm kidding. Just a minute, switch gears. Teledoc or telemeds. If the telemed is accepted by your and covered by your group health plan, the answer is yes. If the treatment and visit is done through the telemed and that's picked up under your group health benefit, the answer is yes, it is. Okay? Boy, that kind of blew that one on ERISA. Thank you very much. No, I'm kidding. Good question. Thank you. Or one occasion treatment in conjunction with the 3 days of time off or in hospital stay will qualify as well as FMLA. Types of serious health condition, pregnancy and prenatal care. We have different types of family relationships. You have a lot of significant others that are dads, right? Does a significant other qualify to go to prenatal visits? No. Does a husband under FMLA qualify? Under certificate of marriage? Yes. So, and I see employers mess this up. God bless you, I understand. Joe works on the line and he wants to take time off to go with his spouse for a prenatal visit. That's my right to do so. I'm supporting my wife, that psychological connection or that issue, hormonal stuff that'll happen. No, I'm kidding. But you know where I'm going with that. It's supportive. And so from that standpoint, the answer is yes. Not a father of a child, the husband of the mother. Okay. Substance abuse treatment. The answer is yes and no. Substance abuse, if you catch somebody and they go into a substance abuse program, that's not FMLA. And quite frankly, whether you choose to keep that person there is up to you, and you can deal with those kinds of problems later. But again, please come to work, and I respect that too, okay? But the answer is no. If they voluntarily enter into a substance abuse program before they get caught by you, the answer is yes. Okay. Pregnancy, of course we understand that. Morning sickness, ultrasounds, blood work, anything that's related to that pregnancy. And this is frustrating for a lot of employers because especially the morning sickness, it's an uncontrollable event. But go back to the philosophy of the FMLA and the Department of Labor, and the family is important and all that. And so make sure that you're understanding that that is FMLA time. Okay. And Missouri does follow the Federal Pregnancy Discrimination Act. What this means is even for smaller employers, what they have to do, it's really simple under Pregnancy Discrimination Act called PDA. It's pretty simple. It just says that you can't treat a pregnant mom any differently than what you would any other employee that maybe has a sick condition. Okay, they have to be treated the same. So smaller employers fall into that same category. When we take a look at critical definitions, unable to perform the functions of the position. Now, Jim had mentioned we work with a lot of folks out in Las Vegas and stuff. Those guys have every policy in the whole wide world, and they have everything documented. They have thousands of job descriptions, everything from hospitality to housekeeping to the bell folks. And each one of those has essential job functions identified. On your job descriptions, do you have identified essential job functions? Think about that for a minute. You have that catch-all phrase, and whatever else we want this person to do, right? The last thing on it. But essential job functions, what the importance, and this is probably more critical in the last 3 or 4 years, I'm jumping to HR stuff here for just a second, but it's related, is the essential job description for a receptionist, just to keep it simple, is to answer phones, essential job function, answer phone, direct that to the appropriate department or to the appropriate person within ABC company, and treat that caller courteously. Essential job function. Additional essential job function is to meet the individuals that come to our lobby, make sure that they're treated professionally and they're engaged with whomever they came to see. Those are the 2 essential job functions. Other job functions that are not essential could be sorting and distributing mail. A lot of reception folks will do that, front desk people will do that, right? But that's not truly an essential job function. Someone else can do that because it's not really restricted to that, what we'll call that front desk thing. It's sitting there all the time and answering the phone and greeting it. So you see the difference in how we're doing that? The reason why I bring it up is because if you have an FMLA or an ADA, you have someone, that receptionist is now in a wheelchair. Can they perform the essential job functions, the phone stuff and the meet and greet? Of course they can, right? That's essential. So they can sit in their wheelchair and do that and maintain their job with the accommodation of allowing that person to sit in a wheelchair. And if they're out on FMLA, that should not, you can bring them back to work, not a problem. But maybe they can't necessarily sort and distribute the mail because they have to carry the mail in the bin or push the cart and push themselves. Okay? And so now when you start to take a look at ADA as well as FMLA, now we're looking at accommodations and all that. That's why that essential job function is important. Sorry about the tangent. I do that every now and then. That's why I need a psychiatrist or a therapist. Yes, ma'am. The question is that something that the employer creates, the essential job functions, or is it something that they create and provide to the employer? It is part of a job description that should be shared with the employee. Oops. Oh, this is such a cool thing. You did what? Well, we fired Joe because he was working at another company while he was out in FMLA. Did you tell him he couldn't do that? No. Do you have a policy that says while out on any medical leave or sabbatical or whatever else that you do, from that standpoint, you cannot work somewhere else? Okay? Do you have a policy that says that? So they're out on FMLA from your company, and coincidentally they can do a job that pays $1 more an hour for someone else and come back to you. Whoops. I knew I would do that. When in fact they shouldn't be doing that. That's a no-no. Okay? So make sure that you have a policy, and you can do these policies. It's not that you can't do them, but so many employers sometimes forget to do that. Just a thought. Continuous leave, intermittent leave, and reduced scheduled leave. One block at a time, it could be, when you take a look at continuous leave, like one block at a time could be just a week, not the full 12 weeks of FMLA. It could be just a continuous block of time. Intermittent is I can't come in today, right? Or I'll be in. You'll love this. This is one of those Las Vegas stories. One of the hostess on the floor, and this hostess would come in constantly or consistently 15 minutes late under FMLA because of her condition, with a cup of Starbucks coffee in her hand every time. Now, I don't know if you guys, God bless you if you go to Starbucks, that's not the key, but there's always a line at Starbucks. You can't, if you're ever first in line at Starbucks, get a lotto ticket, I'm telling you. But 5 cars, 6 cars back, waiting 10 minutes to get your cup of coffee, 15 minutes late to work, come on. We'll talk about that in section 2 of FMLA. Got that covered for you. But intermittent leave, reduced schedule leave. Joe can work 40 hours a week, but he can't work any overtime. Gotcha. I can't work 41 hours, but I can work 40 hours. Because my doctor said under my FMLA bad back condition that I should be restricted to only working 40 hours a week. So the 6 days that you have everybody else in the whole wide world working, except for Joe now, and then Joe is out golfing on Saturday, calling his buds at work or texting them, hey, I just got par. FMLA, we'll talk about that, but the answer is that's what we mean by reduced schedule work. Can you challenge that? The answer is maybe so, kind of, sort of, yes. When we take a look at intermittent leave, employer must, I didn't say may or could, must use the shortest increment of time employer uses to account for other types of leave, provided it's not greater than 1 hour. Okay? Salaried individuals, God bless us, we get paid for, our salaries are all based on working. They pay us for working 25 hours a week, but they make us work like 70, you know? No, I'm kidding. But they base it on a salary, and then from that standpoint, I have FMLA today, but I'm going to work from home too. How do you track that? Right? Should you be tracking that? Salary. The answer is yes, you can. But what you have to do is make sure that you have good records or indication from that salaried employee how much time that they're actually spending working and how much time they're not. FMLA does allow you to track time on salaried individuals, okay? And then it's not that unusual for an employer to use a reasonable method to track FMLA, because on salaried, they can charge half a day, 4 hours of PTO, or 2 hours for a salaried individual, and then they still pay their full salary, but part of it is a PTO, right? And so from that standpoint, I'm not going to go into the wage and hour stuff, but that's okay under FMLA. Wage and hour, that'll be phase 2 later on. Yes, ma'am. The question is, a salaried worker can still work at home and be paid their full salary. The answer is yes, they can. It's up to the employer whether they want to allow that salaried individual to work at home. However, just like hourly, if a salaried worker is not allowed to work at home, but they're answering email and stuff like that, are they working? The answer is yes. Do you have to pay them? The answer is yes. And then that goes to your salary. And then you can discipline them for doing that, like you'll do that. And the answer is no, but you could, but you won't.
But they still could be on FMLA because they can't come in,
Yeah.
but they can work from home with their condition or whatever.
That's correct. The Department of Labor has said that you can track the FMLA time and break that down. So if you actually base that salary on 40 hours as example, and you know the individual has worked 2 hours and the rest is 6 hours is FMLA leave time. Most of you won't do that, but you can. And I understand why you don't do it, because it's too difficult, right? Calling in sick, oh boy. When a Department of Labor investigator comes in, not if, but when, and the investigations are going up exponentially each year. I'm 25 and I do a lot of these. I'll go into this in the other section, but I'll give you a taste. Or I've got it here too a little bit later. They're going to want to know, here's the typical drill. Hi, employer. You're the employer representative. Yep, nice to see you. Oh, crap, you know, why are you here? Well, I'm from the Department of Labor and I'm your friend. Please believe me. And I'm here and I just want to take a look at some FMLA stuff, okay? Okay. What does that mean? It means to you as an employer, stop, look, and listen, the ABCs, and call your professional. I don't care who it is, just call somebody that's really good at FMLA. Because most often, although it does occur now under different types of programs that the Department of Labor has, they can come in and just do random reviews of FMLA, check your posting, check some of your records just because they're in the neighborhood, and they have to do so many investigations anyway per quarter. That can happen, but realistically it doesn't, because they don't want to take their time unless there's a complaint or money in the game for them. You fall into an industry, low pay, high turnover, or something about your industry that they like. Car washes are phenomenally picked on by the Department of Labor for many different reasons. Fast food, franchisees, manufacturing, job shops. Do you know how they count 50 employees? You know what the first thing they'll ask you on your 50 employees? We don't have 50 employees, no. We only have like 47 employees. We don't have 50 employees. Never have, never will, because we're always very careful not to go over that. Okay, show me your payroll register. How many employees did you forget to take and from active status to term status? Right? Think about it just for a minute. You only have 47 employees, honestly, you only have 47, but you show them the payroll register and it has 125 people on it. Well, they're not here though. they were gone, they left last month and we haven't hired that person. And you see how the stories start? God bless you. And my response is, you did what? Clean up your payroll registers, and if you've got 47 employees, then dump all the others that shouldn't be there, like terminate them off of payroll if they don't need to be there. Well, yeah, we terminate them, but we kind of hire Joe back, 3 months from now. When he gets sober, we'll hire him back. Or when his therapist releases him to come back, please come to work, please. And so that's what you do. God bless you. So simply calling in to work. Here it is. Hi, I'm from the Department of Labor. I'm here to help you. We're going to do an FMLA review. I'm not going to tell you why, other than we've had a complaint. I'm not even going to tell you that. I'm just here to take a look at stuff. I want to see from you, this is where they start. This is where you go, oh crap. I want to see for the last, they'll be kind, instead of 3 years, they'll ask for 2 years. I want to see all of your FMLA records for your entire organization over the last 2 years. All of your 380E forms, all your 380F forms. I want to see the rights and responsibilities. I want to see all the absences that were called off for FMLA, either continuous leave or intermittent leave. How am I doing so far? And in addition to that, I want to see all of the absences that were called off by your employees. What? For 2 years? And your response should be, you know, we'd love to give you that, and we can. It'll take us a little bit of time to collect that. And you're going, oh my God, I don't even know if we have that stuff. And the answer is, no, you don't, right? And then you say, excuse me, it'll take us a while, but tell me what you really want. First negotiation. Okay, well, let's do this. Let's take a look at Department 11 and 12. Let's go back 6 months to a year. We'll start there, and if we need to go further, and give me all that stuff that I asked for. It's still a oh crap moment, right? But at least it's not this big. And then you bring your expert in. Well, it'll take a little bit of time. Can we schedule? Yes. Yes, I'll come back, or we'll revisit this. But then this is what I'm looking for. I'll give you the information. We'll submit it to you. You get your expert in, please, please, please. Whenever you hear the DOL, whether it's for a wage and hour issue or an FMLA issue, if you hear those 3 letters, call your expert, because they can talk to, do whatever it is that they want, and ask you for whatever it is that they so desire with regard to documentation. Sometimes it goes a little bit out of scope, and you need that professional to keep it tight, okay? If you walk away with anything over these next few hours, that's the best piece of advice that I can give you. Okay. From that standpoint, that's what they're after. So you track this by day on a calendar. You track the claims, because FMLA, I'll just say Joe, my spouse, and my 6 kids, or let's make it 12. I have 12 kids. I have 12 kids, a spouse. My spouse has, oh God, here we go again, anxiety and depression, 2 FMLA. My number 1 child has an emotional thing going. My second, because I live with them, and my second child has asthma, and my third child has a skin condition, all of which are FMLA. How many FMLAs do I have? Do I have 1, because I'm 1 employee? Or do I have, what did I say, 1, 2, 3, 4, let's go 4, 5, or 6. I have 5 or 6, okay? Not 1. I have 5 or 6 FMLAs going. Because for my number 2 child, it says frequency and duration on that FMLA 380F form is that my number 2 child can have that allergic reaction, you know, skin thing happen 1 time per month, lasting a day. My spouse's condition, because she's married to me and no other reason, can have that happen 4 times a month, lasting up to 2 days. And my first child, because of that, can have the condition that's going to happen once a week during hay fever season or whatever, lasting 4 hours. Because take medication or the respirator, they're okay for the rest of the day as long as they stay on that, right? So how in God's name are you going to know which one? Are you tracking those independently? And your supervisor, God bless them, out on the shop floor, is sick of me because I'm never there. I'm off on FMLA, and I'm one of those type of employees that say, I don't have to tell you nothing, I just tell you that I'm not here. That's wrong. They have to identify FMLA, and they need to identify which FMLA that condition is for, because they all end at different times. Recertifications and all that, they have to tell you. Now, shame on you. Not really, because all of you fall into probably the same ballpark, is that you're not tracking them that way. You're just kind of tracking whatever it is you can, how you can, when they tell you, or when you get it from your supervisors or whatever. Now, did the Department of Labor say to you, just give me the stuff that you kind of sort of had? No. Here's number 2. We talked about essential job functions as being important. The next smart thing I tell employers to do, or I ask them to do, I tell them, I'm telling you to do this. Department of Labor investigation and FMLA, okay, you're worried about some of your chatterbox supervisors, what they're going to say, open their mouth. It's kind of scary, right? Sometimes they're really good, but they like to volunteer stuff. The M word is a very, very bad word. M word. When a supervisor or manager hears that M word, they take it to the front office, period. I don't care if that M word's about a family member, one of their employees, for their dog, or their cat, or their parakeet, or parrot that's going to live longer than they do because of gray parrot's disease, and that can be an FMLA event too. And so the M word is a medical word. A DOL investigator comes in and they want to talk to supervisors. What do you do when an employee tells you about a medical condition? Medical, M word, front office. That's it, they're done. That investigator stops that answer to question. It's not a run-on, right? It's an M word. They take it to the front office and it's done, and then it's in the control of the company. A supervisor and manager is the company. Don't think for a moment that you can excuse the actions or statements of a supervisor or manager. You cannot. They are a representative of management. They're viewed that way, and whatever they say, they're accountable for. Okay, boy, I killed that puppy, but we're good. Top employer mistakes. You forget to provide notice. You forget sometimes to maintain group health insurance. You want to put them out on COBRA. FMLA leave is not a COBRA qualifying event. No way, shape, or form. It can turn into one, but it doesn't start out as one. The employee has a responsibility to pay their copay amount. You can take that out of any existing PTO, continue to take it out of pay, whatever you want to do, or they write you a check. But they still have that responsibility to pay you. If they don't pay you, which is kind of stupid because they're out on FMLA, they need to go see their doctor, so if they don't pay you, can you terminate their insurance? The answer is yes, you can, because you can't give them an unfair treatment paying 100% of their coverage when everybody that's working for you has a copay. That's not fair to everybody else. So they have an obligation. You make arrangements, document those arrangements to get that upon their return or however you work it out, but they owe you that money or they need to pay you that money. Okay? If they decide, I don't want to, I'm not going to do that, then at that point it's still not a COBRA event because they have medical available to them. They elected not to participate in that medical, so it's not COBRA qualifying. Bud is my timekeeper. You know, Italian, I run on a lot, so. Others, assumptions. Failure to grant FMLA based on a misunderstanding of what qualifies as a serious health condition. That's the technical answer of, he didn't ask for FMLA, so I'm not going to give Joe FMLA. It's his role to tell me that it's FMLA qualifying. I don't have to tell him. That's my secret as an employer. Don't have to tell you. I don't have to tell you qualifying. The answer is no. That doesn't work. If you know the condition that I have or my family member has, and you know it kind of sort of maybe could be FMLA, you as an employer, as a supervisor or manager, that representative that works a shop floor and doesn't come to the front office with that M word, right? Doesn't tell you. It doesn't change the rules of FMLA. It just digs the hole a little bit deeper for you because you took disciplinary action either on your point system, on your attendance, or you did something to Joe that wasn't very nice. Joe is going to file on you. Almost guaranteed. Google how to sue your employee for FMLA. Just do it. Please, I ask you. I beg you to do that. And then look at the, I don't know, a couple hundred responses from your local attorney that will help. Not your CPA, your attorney. No, I'm kidding. 2 minor conditions can make an FMLA condition. Terminating an employee during or following an FMLA. Be very, very careful. 12 weeks in a day doesn't work anymore. Okay? Can't do that because of under ADA and also FMLA, it gets a little sticky because now it's kind of looked at as a retaliation for going out on FMLA if you terminate them within a reasonable period. And I love these doctors. Joe is out for 12 weeks because he broke his left little toe. Can't walk, okay? I can play baseball, I can do a whole lot of other stuff. That's in phase 2, we'll talk about that, but I can't come to work, sit at my desk and do my design stuff. I can't do it. I'm off for 12 weeks. Doctor says, you ready to go back? I go, God, no, I'm not ready. I don't want to go back yet. I can go on long-term disability. I don't have to go back. Just do something with my toe. Hit it with a hammer. I don't care what you do. Just, I don't want to go back. And so he said, okay, I'll write you off for another week. And now I'm at the 13 weeks. And then what happens? I go, I don't want to go back. And then, or maybe I can't go back. And the doctor does what? He writes me off for another week. And then another week. And then another week. You've seen it, right? Because they don't give you a clear picture on return to work. God bless them, and I can understand because each individual is different. I'm totally different. But every individual's condition is based on that individual. There's no box that you can throw all your employees in, or even 10% of your employees, and say they're all the same. They are the same height, same weight, same everything, same age. So that box for all of these FMLA is this way. It doesn't work. It's your FMLA, your condition, even if your condition is the same as mine. You can go right back to work with your broken toe after 2 weeks without crutches. Me, because of the psychological impact my toe has on me, I can't go back to work yet because I have to go through physical therapy, I have to go to psychotherapy, and my doctor likes me more and gives me something else to do. Writes me off for 6 weeks. How cool is that during the summer? Got it. Okay. So be very careful. Denying leave for parents. Failure for granting, and this is where your supervisors and managers commonly will make mistakes, is when we look at parents. Disciplining employees. Adjust job performance goals is a retaliatory action. I'd love to give Joe 25 cents more an hour, but how can I justify giving Joe 25 cents an hour when Pete and Mary get the same amount and they never miss a day's work, but Joe has been out on intermittent leave, and when he is here, he has a restriction that he can't work overtime, or he can only work 40 hours a week, and Mary and Pete are working minimally 48 hours a week. I call them, they're here. Joe, I can't work because with my toe, my doctor says I can't work more than 40 hours a week, so you'll have to do it without me. Bam. No 25 cents an hour. That ain't right. So Joe does what? Calls the Department of Labor and says, my mean employer, not because of anything I did, it's because of my injury, said I don't get my 25 cents an hour raise. Right? And they ding me as far as attendance on my performance review. I haven't missed a day of work except for my FMLA. That's not true. I come in late. Anyway, I call in. But I didn't tell that to the Department of Labor, did I? The Department of Labor said what? I want to see all of your absence records for Department 11 and 12. I also want to see all of your FMLA, continuous and intermittent, and partial day call-offs. You see where they're going now? See where the link comes? And if you can't separate them, how are they going to separate them? Right? Who's right? Joe with a little toe? How are you going to defend that? Pay me now, pay me later kind of thing, pay your attorney. They'll be able to skirt and get that probably reduced, but they're not going to get it to go away. Okay? Notification process. Being able to notify, they're going to take a look at it from the standpoint, did you give that rights and responsibility, that 380E form, within 5 days of when the employee made you aware that his condition may be FMLA? What date did they tell you? When did you get the form? I don't know. God bless you, and I understand, but those are the questions that they're asking. Treatment, termination, leave denial, point system, no fault, failure to recognize sufficient information for designation, and this comes from the shop floor, from that manager, supervisor. And God bless them, they've got a hard job, and so I tease a little bit, but they truly do. And so they're trying to run an operation to make the company profitable, right? And so sometimes they're told things and then interpret it themselves. It's still a management representative. There's no ands, ifs, or buts in retaliation. Military exigency leave. Out of all that stuff that we do for our clients across the country, less than 1% of that has to do with military, not very much at all. So I'm going to gloss over this. If you have any specific questions, just ask me about that. I'd love to talk to you about it. So you must post your general notice, so look for that. Provide FMLA policy in your handbook. Should do that. The 381 must be in writing. The rights and responsibilities should say how you're going to handle stuff. And I haven't talked about key employee. Now, key employee is not the person that you designate as being a key employee. There are financial and operational issues that you have to look at when you look at a key employee, because what you're doing is that you're saying that your key employees, that would be a high executive. I can't remember the number, I just lost it, but I'm going to say 110, 120,000 plus, I don't recall the specific number in compensation, is a key employee, and they're exempted from FMLA. In other words, they're not covered by the FMLA if you tell them that they are a key employee. Okay, and they go off on a 12-week leave as an example, and you call me, you designate me appropriately as a key employee. I'm making a lot of money, and I'm head of your IT, and we can't go 12 weeks without someone being in that role. You are a key employee. You tell me that, I have a right to replace you. Be careful. Make sure you follow the appropriate documentation stream if you do that, but the answer is you can do that. You'll see it in banking, business to business, technology, stuff like that. Notifications, we talked about that already. One thing I wanted to talk about during this session, and I encourage you to stay for the other session because I'm going to tell you how to deal with a lot of this stuff from a practical side of it, if you can. But retroactive designation is permitted as long as the employee isn't harmed. So the supervisor forgot to tell you that Joe had an FMLA qualifying event for his spouse, rightfully so, that I needed to take time. I had a point system in place, and I was dinging him on the points all the time, and I was getting ready to terminate Joe because he ran out of points. And then the supervisor kind of said, well, yeah, you know, I hope we don't have to do this, because really the only reason he was taking that time off was to care for his wife, supposedly. Well, why didn't you tell me that M word? Remember, you're supposed to tell me that up front, but didn't. So now you potentially erase, first of all, you don't fire me because I'm out of points, so let's start there. You don't put me on a leave of absence without pay, pending investigation, and all that stuff that we love to do. I love to use that. Oh, HR thing, never ever fire anybody, period. Never do that. And you'll be really safe. You know what you do? You suspend pending investigation. Suspending without pay, suspending is the same thing, kind of, sort of. They're out of there, right? You always suspend. And then you let the person know that you suspended, Joe, that they're suspended without pay, and you'll get back to them following the investigation, and the investigation will take about 5 days. So my investigation is Joe screwed up. Joe screwed up. I suspended him. 5 days, I call him back and say, you're fired. Okay, got it. Here's my investigation. No attorneys, right? Here's my investigation. Just stick it in the top of your corner of your desk. That's your investigation. You talk to Hank and Mary. Did he really do that? He was that stupid? Are you sure? Yeah. Who else saw it? Yeah, got it. Because you can't do a post-investigation after I file a claim for age, race, sex, whatever, with the EEOC or somebody. But if you ask me and you write all that stuff down, then you come over here and say, I'm done. Say, Joe, I told you I'd call you in 5 days, you're fired. Now you've covered every base. And so if there's a claim that comes from the EEOC because I'm over the age of 40, even though I'm only 25, right? And I happen to be a mixture of Italian and, I'll just say, I don't know, Indian. I'm 95% American Indian, protected class. You didn't like me, so you fired me for that too. And whatever else I can creatively and get someone to listen to me. You've got it covered because you did what? You put this in the corner of your desk, you talked to a few people, you completed your investigation, then you fired me, and then that's what you tell EEOC. Sorry, different story. You did what? No, I'm kidding. Okay, group health benefits, maintain them. COBRA, we talked about that already. Best practices, review your policy and procedure. Consistency is a key. There's ways, and of course, as we said, we do this working with our friends at BeneFLEX. We can track all of this stuff for you. If you're a larger employer, there's ways that we fix this. I've gone in to our friends in Las Vegas, and they get hit all the time, God bless them, with different kinds of FMLA. The worst one I had is a Department of Labor investigator come in. It was unprecedented for me, and I've been doing this for a long time, where that Department of Labor investigator came in. He was just transferred into the Las Vegas area, brand new person out of California. He came in with his team with 5 Department of Labor FMLA investigations against a single employer. 5. That has never happened to me in my career where they stacked 5 at the same time. And if there isn't an oh crap moment, if there is one, that was it. Because they were just, they wanted to make an example of a premier gaming hospitality and nail this, take it all the way through and get millions of dollars settlements and all that sort of crap like that. 5 at the same time. Typically it'll always be 1. Just 1 they'll come after and a complaint. And then when they do that, all that other stuff that we talked about, they're going to get you on it anyway. They know that. And so the whole net of it is, if you didn't harm anybody, it really works out kind of coincidentally that fine and penalty you'll pay without going through the court system, that's in phase 2 that we'll talk about. If you don't do all of that sort of stuff and you don't fight it and you work with them, if you're between 50 and 100, that fine and penalty is going to be maybe 10 to 25,000 when it's all said and done. But that's affordable for that little guy, right? That little employer. If you did the same thing and you're 500 to 1,000, well, now you're at the 35, 40, 50,000, which is still kind of affordable. They're going to sting you is what it amounts to because they have that right to do that. If you fight it and you really did something bad and there's back wages, and we talk about that in phase 2, stay tuned, to be continued, then you get to the millions. And I'll show you how that happens too. So Department of Labor investigations, I know I'm running a little bit over and I apologize. So be careful. They'll do systemic FMLA reviews just to make sure. If they come in and they say, and it's truly a systemic FMLA review, they're just wanting us to come in because they're in the area doing another investigation, but that investigator has to, it's kind of like you always think the police have a quota that they have to meet. So do these investigators. They have to do so many investigations. They're going to do what they think is an easy investigation with another employer in the same area, just to do a generic FMLA systemic investigation and look at stuff. And they're going to be out of there and complete that. Don't interfere, restrain, or deny FMLA. Don't discriminate or retaliate. They have a right to file a complaint, or they can also file a private lawsuit, get a right to sue letter, stuff like that. And the action must be taken within 2 years after the last action, okay, or 3 years if the violation is willful. So a terminated employee, what that means, can take suit because you terminated them once they figured out that you did something wrong under FMLA 2 years after, within 2 years after the fact. Then dig up all your records, going back potentially 3 years is what they could ask for. So now you're 5 years into it, right? Reinstatement, back pay, front pay, liquidated damages. Turn it over to question. Was it okay? I didn't bore you too much, did I, with this one? Wait till we get to ERISA, you'll love it. Questions? Yes, ma'am. The question is, we track all of our absences as PTO time, but not as sickness time, and they just went over 50, correct? The answer is yes. Now, in order to determine whether you're an FMLA qualified employer, I didn't speak to this. An FMLA qualified employer is if you look at the previous year, for over 20 weeks, you had more than 50 is the calculation, okay, when you look at it from that perspective. If you're a government entity or a church, you're going to love this rule. It says that if you're a government entity, like a municipality as an example, or a church, and you automatically qualify as an FMLA employer. Okay, you're an FMLA employer because you meet that government entity church, not-for-profit scenario. Okay, stop. You qualify as an employer. However, if you're a small municipality or a church having less than 50, the other part of it says that the employees must work for an employer that has more than 50 employees. So you don't get FMLA, not because the employer is not qualified, it's because you as an employer don't work for you as an employee don't work for an employer that has 50 or more. So you don't have to do it.
So if you have less than 50, you don't have to do it.
You don't have to do it. But stay for the other part anyway. Please, no, I'm kidding.
Is that any nonprofit or just government, church?
Government, churches, nonprofits.
All of them.
Yeah, be careful because I want to take a closer look at what you're considering nonprofit.
So did you say yes or no to the segregation of the PTO?
I'm kind of like an attorney. I won't answer your question. You should track your sick leave and your potential FMLA separately from your PTO. Very important. Other questions? Yes, ma'am.
I'm having problems with
$25 is, I'm having problems getting employees to complete their FMLA paperwork because the healthcare provider is charging $25 to complete that 380E or 380F. That's very low. It's up to 50 now. In some areas, it's even higher than that to get them to fill it out. That is their problem and not your problem. Once an employer, and this is in part 2, but I'll tell you, once an employer ask for that information and they don't provide it, and you send a reminder and all that sort of stuff, you do what, document it, they don't provide it, you can make a reasonable determination and deem it whether it's FMLA qualifying or not. Now, obviously, if it's a broken leg or a pregnancy or something like that, you know it's going to qualify and just let it go. But if it's suspect, like my migraine or my GERD or my little toe, those kinds of things, at that point, what you can do is you can say, no, I'm not buying this, and I can make a reasonable decision that this doesn't qualify as an FMLA condition. The next thing I'll say, and even if you're wrong on that designation, shoot, this is part 2, even if I'm wrong on your designation, but I made my decision based on the facts I believe to be the case, because now that I terminated somebody because of all their absences and they come back and here's all my medical stuff and they paid that $25, you're still okay. The Department of Labor is going to go to the employee. Shame on you. Shame on you for not letting them know that information, and you're going to be fine. It's a little bit more detailed than that, but that's the answer to the question. Yes, ma'am. Okay, churches and government entities, we'll use that, and some other non-profits, but I want to qualify that. The law says that the entity, that small municipality or that church, is an FMLA qualified employer. That's the law. However, if you have less than 50 employees, that employee does not work for an employee that has more than 50, so that is not a covered employee. So the net answer is that that's not an FMLA qualified employer. I'm summarizing the regulations. I know it kind of circles on you, but the answer is no, if less than 50.
What if they're 50?
50 or more is,
50 or more, is that?
yeah, 50 or more. The other thing that becomes important when you take a look at this stuff, as I mentioned before, is make sure that you clean up your payroll registers if you're that close. Okay. Other questions? Yes, ma'am. Okay. When we take a look at Air National Guard or reservists that have to go for their 4 weeks or long 12-week training or something like that that occurs, are they covered under the FMLA? The answer is no. However, there are other leave requirements for reservists that they do fall under. Thank you for your question. Other questions? This scares me. No, I'm kidding. Okay, the question is, I have an employee that has 2 positions with us. One is full-time and the other is part-time. She wants to take medical leave for her part-time position, but not for her full-time position. Okay, when I look at that, there's some other issues, because now we're getting into DOL wage and hour stuff. And when we take a look at the DOL wage and hour, is it of the convenience of the employer that you're separating the roles out? If you're in food service sometimes and you have tip people, you know, like servers, there's different rules. And so I'd want to dig a little bit further, but you could be potentially in a challenge because if it's at the convenience of the employer, the answer is you're probably missing out on some full-time if you're not, or overtime for that person. Starting with that, but to allow that leave, that would be at your discretion, but if that medical leave is FMLA qualifying type of condition, the answer is I would apply it to both positions. That's the way I would look at it. But every case is a little bit different, so I don't want to say too much without knowing, but when I look at a generality, that would be my first view. Okay. Good question, very good question. Okay, the question goes to coverage for domestic partners, if they're covered under the FMLA or not covered, and then the second part of the question goes to dependents of domestic partners. And so when we take a look at it, a domestic partner can be in loco parentis of that dependent, which means they would be able to take FMLA for that dependent because of that in loco parentis in place of a technical parent, they're there. When we take a look at domestic partnerships, now we're getting into state leave. If state leave recognizes, and I think when we look at the true definition of a domestic partnership, some have different rules as far as what qualifies as a domestic partner. At the state level, if they recognize family leave for a domestic partner, then it would be family medical leave, not necessarily FMLA qualifying, but family medical leave qualifying. Here in Missouri, the answer is that would not qualify. Okay. Common law is different than domestic partner, and common law, again, here in Missouri is not recognized, so it doesn't count, but some states do recognize common law. I think there's about between about a half a dozen states that do. And so in a situation like that, I'm going to say what's coming to mind is New York. I could be wrong, but I think New York recognizes common law. And so in common law, FMLA would apply to common law marriages. Yes, ma'am. And others, come see me after the break, okay?